Something historic just happened, and if you're a gun owner in America, you need to pay attention. The Supreme Court just issued a 6-3 ruling that's sending shockwaves across the nation, and it could completely change the future of concealed carry laws as we know them. This decision isn't just another legal update, it's a turning point that's dividing the country, alarming gun owners, and raising serious questions about how far the government can go when it comes to your right to self-defense. In today's video, we're diving deep into the controversial ruling that's sparking outrage, celebration, and confusion all at once. Why did the court rule this way? What does it really mean for your rights? And how are states preparing to respond, fight back? There's already talk of new restrictions, federal challenges, and potential loopholes that could redefine the Second Amendment landscape overnight. You'll want to hear what some justices said in their opinions because their words reveal something far bigger than anyone expected. But before we get into that, if you believe in getting real information without the political spin, make sure to subscribe right now and hit that like button. Your support helps this video reach more people. That's how YouTube's system works. The more engagement a video like this gets, the more people can actually understand what's really happening behind these court decisions. So if you care about your rights and want to stay informed, your subscription really does make a difference. And while you're watching, leave a comment below and tell me what part of this ruling shocked you the most. Was it the 6-3 split, the state's reactions, or the hidden consequences no one's talking about? Stick with me until the end, because the final revelation is something the media isn't even covering, yet will absolutely leave you speechless. This is more than a legal story. It's the beginning of a massive shift that could redefine what freedom means in America. Welcome to Gun Sense Media. 1. Opening shock, Bruen case, and court decision. Stop, listen, and pay attention. What the Supreme Court just unleashed may rewrite everything you thought you knew about gun rights. A 6-3 ruling has rocked the legal foundations of concealed carry and put every gun owner on edge. Today, I take you step by step through the decision, the fallout, the hidden dangers, the political war brewing, and a twist at the end that even most experts aren't talking about. The case at the heart of this storm is New York State Rifle and Pistol Association versus Bruen. Until this moment, New York's law required any would-be concealed carry applicant to show a proper cause, something beyond ordinary self-defense, a special justification to distinguish that person from all others. Many states had similar may-issue systems. In Bruen, 2 law-abiding New Yorkers challenged the state, claiming this requirement violated their constitutional right to bear arms. The case eventually reached the Supreme Court, and in June 2022, the court delivered a 6-3 decision that struck down New York's proper cause mandate as unconstitutional. In that decision, the court held that requiring proper cause is incompatible with the Second Amendment's protection of the right to carry a handgun in public for self-defense. The traditional balancing approach, where courts weighed a law's burden on rights against the state's interest, was rejected. Instead, the court ruled that if the Constitution's text covers the right, the state must prove a matching historical tradition of regulation. Otherwise, the law fails. Modern public safety arguments alone are no longer enough, and many restrictive laws are now vulnerable. 2. The new legal test, gun owners' reaction, and safety critics. The new legal framework demands that laws align not just with the general idea of safety, but with historical analogs. Courts must examine colonial-era statutes, early American laws, and centuries of firearm regulation to see whether there is a tradition of restrictions similar in kind. If no historical match exists, the law is presumptively invalid. Immediately, gun owners and pro-rights advocates recognize that many state laws are now vulnerable. States with discretionary may-issue systems that evaluate subjective need may be forced to abandon them. Even states with shall-issue laws may see challenges to the criteria of refusal or disqualification. Gun owners worry that obstruction may shift. Instead of straightforward denials, they could face stacked training mandates, burdensome moral fitness tests, hidden administrative delays, or overly broad definitions of where you're not allowed to carry. Opponents of the ruling argue the decision weakens states' ability to respond to violence. They warn that courts ignoring empirical data about gun violence and crime dynamics is dangerous. The dissenting justices argued that without balancing tests, states lose flexibility to impose workable, evidence-based regulations. Some public health researchers warn that removing training requirements entirely correlates with increases in gun assaults. The decision elevates constitutional formalism above real-world risks. 3. Dissenting opinions, litigation surge, and state flashpoints. The dissenting justices Breyer, Sotomayor, and Kagan criticized the majority for divorcing from factual reality. They cautioned that judges are not historians and should not be burdened with reconstructing centuries of regulation. They emphasized that modern firearms, urban settings, mass shootings, and mental health crises have no perfect historical parallels. By rigidifying review, the court may create unreasonable constraints and judicial missteps, weakening compromise and reasoned regulation. Since Bruin, hundreds of cases have been filed challenging gun laws, including concealed carry regimes, bans, magazine caps, suppressors, and sensitive places rules. Many laws have been upheld because courts found acceptable historical analogs, but some symbolic or restrictive laws have fallen. States with heavy restrictions, New York, California, Maryland, Massachusetts, New Jersey, and Hawaii, faced the most pressure. New York responded with a revised concealed carry law. California faces lawsuits targeting good cause and moral character requirements. Hawaii has a case where permission from property owners is required to carry, which challengers argue effectively prohibits public carry in much of the state. 4. Private property rules, political fallout, and legislative strategies. Bruin did not eliminate the idea that certain places can be off-limits to firearm schools, government buildings, courts, and other sensitive places remain restricted. But the exact scope of sensitive places will be hotly contested. Private property owners banning firearms may face constitutional challenges if their rules conflict with core public carrying rights. Employers prohibiting guns on premises may need to re-examine those bans. Politically, the ruling raises the stakes. Gun rights advocates celebrate a constitutional victory, while gun control groups warn of chaos. State legislators are scrambling to draft Bruin-proof laws that hide regulation behind historical pretense or shift burdens subtly. Some states may adopt permitless carry. Others may impose mandatory training or insurance mandates. Legislative sessions are now intensely focused on defensive gun law drafting and heated campaigns. 5. Risks, backlash, and legal uncertainty. The decision is not without danger. Aggressive rulings may provoke public backlash or push Congress toward federal regulation or even constitutional amendments. The historical test itself is flexible. Some laws that seem beneficial may be struck down if analogs fail. Key open questions remain. How far can modern regulation diverge and still count as analogous? Can restrictions on magazines, feature bans, or technology survive? Will courts allow judicial innovation or demand strict fidelity? These rules are still being written in real time, creating uncertainty and tension for both lawmakers and citizens. 6. Hidden twists, empirical evidence, and law survival rates. Most analysts overlook a critical point. This ruling may be the first step in challenging far more than just concealed carry. Weapon type bans, limits on accessories, magazine capacity caps, and registration regimes could all be questioned if historical precedent is lacking. Some states removed mandatory training after Bruin, and data suggest a 32% increase in violent gun assaults relative to predictions in some analyses. Despite this, many laws survive under the new test if historical analogs exist or if restrictions are modest. This indicates a gradual evolution rather than an immediate revolution, but symbolic cases have ripple effects nationwide. The real story is in both the data and the broader judicial strategy. 7. Practical guidance, global perspective. If you own a gun or plan to carry, it is crucial to track pending legislation in your state and monitor local court rulings. Don't assume rights are settled. Favorable decisions might be paused or appealed. Connect with legal defense organizations and advocate for training, carry safety and clarity in rules. Globally, this ruling echoes beyond America. Nations with strong gun traditions watch U.S. precedent, and other constitutional democracies may face pressure wherever history versus modernity conflicts. The victory or failure of this historical test approach resonates far beyond firearms. Finally, share your thoughts. Which part surprised you most? The historical test, the risks of removing training rules, or the possibility of challenging accessory bans? Comment below. Subscribe, and like if this video helped you understand the hidden realities. Your engagement ensures more people see this analysis. Future videos will explore emerging state rulings, upcoming Supreme Court cases, and how rights might shift next. Stay tuned, the next revelation could shock even you.